Hello everyone, and thank you for watching this video. In today's video, we will be looking at the topic validity of a will, formality. This is a foundation topic within wills and the administration of estate. Stay tuned to the next slide. Let us now look at a quick illustration. Do you have a valid will? If the answer is yes, then there are three requirements that must be satisfied for the will to be valid. There must be mental capacity, intention, and formality. Do you have a valid will? If the answer is no, then the rules of intestacy will apply. We will discuss rules of intestacy in another video at some point in time. What is a will? A will is a document that sets out how a person, normally known as the testator, wants his or her property to be distributed upon death. There are three main requirements for a will to be valid. That is mental capacity, intention, and formality. In today's video, we will be looking at formality. What is formality of a will? According to Section 9 of the Wills Act, formality must be satisfied for a will to be valid. That is, no will shall be valid unless it is in writing and signed by the testator or by someone other than the testator by the testator's direction and in his presence. That it appears that the testator intended by his own signature to give effect to that will, and the signature is made or acknowledged by the testator in the presence of two or more witnesses present at the same time, and each witness must sign in the presence of the testator. Let us now look at each of these requirements in turn. The first requirement is that the will must be in writing. The will can be typed or handwritten. It doesn't matter. The use of both will always raise a question. So it doesn't matter how the will is drafted. The next requirement is that the will must be signed by the testator in the presence of two or more witnesses. The testator's signature or his or her usual signature is sufficient, or any other mark intended by the testator to be his signature. Okay? It can be signed by another person, so the will can be signed by another person at the direction of the testator and in the testator's presence. It must be noted that with intention to give effect to the will. So there must be intention by the testator to give effect to the will. And the signature, whether by the testator or someone acting on behalf of the testator, can appear anywhere on the will. So, just to make it clear that the testator must sign before two witnesses at the same time. Let us now look at the next requirement. The next requirement is that the will must be signed by each witness in the presence of the testator. So the witnesses do not have to sign in the presence of each other, but in the presence of the testator. One may ask, who cannot witness a will? According to Section 15 of the Wills Act, these are some of the persons who cannot witness a will. So a blind person, beneficiary, a spouse, a minor, someone who lacks mental capacity, or someone who is illiterate. They cannot witness a will. Let us now recap. According to Section 9 of the Wills Act, there are conditions that must be satisfied in order for there to be formality of a will. So the will must be in writing, it must be signed by the testator in the presence of two or more witnesses, and the witnesses must sign in the presence of the testator. A point to note is that someone who drafts the will, so a will drafter, should not benefit from the will. In addition, any additional documents must exist at the time of the will to become part of the will. In order for there to be a valid will, 3 conditions must be satisfied: mental capacity, intention, and formality. We have looked at mental capacity and intention in our previous videos, so please be sure to check those videos out. And today we have covered formality. Thank you for watching this video. Please continue to like, share, and subscribe to my channel for more videos.